Antar Jones. Mr. Jones obtained a Juris Doctor and a Master of Law in Taxation from New York Law School in 2009, and he established his own practice, the Law Office of Antar P. Jones, 13 years ago. His areas of focus include estate planning, probate and administration matters, estate litigation, and taxation issues. He is a super lawyer, rising star for 4 consecutive years from 2016 to 2019. Mr. Jones teaches, writes, and has presented on numerous occasions with respect to the topic of taxation and trust and estate matters. To quote Mr. Jones, your estate is more than just your assets, it's your legacy. And we are here tonight so Mr. Jones can share his knowledge as to how you can protect that legacy. So without further ado, Mr. Antar Jones.
Okay, so I wanted to talk with you guys about trust and estates, about what I do, and about how that might be able to help you. All right, so I got some notes here. I have them on my phone, but I'm going to do the old-fashioned way. Okay, so I wanted to talk about 4 or 5 things: wills, power of attorneys, healthcare proxies, and living wills. Something called appointment of agent of disposition of remains. That's a form that gives somebody the ability to deal with their body when you die. These topics are not going to be very pleasant because they're always talking about what happens to us afterwards. And then trusts, right? And those are a big deal right now. Let's talk about what happens if you don't have a will. Okay, so if you don't have a will, you die what's called intestate. That means that you're going to go by the rules of intestacy, and those rules are rules that the state has already made. So, and I'll tell you some of the rules. Okay, so if you have a spouse and no kids, everything goes to the spouse. If you've got a spouse and kids, the spouse is going to get the first $50,000, and then the spouse is going to get half, and the kids are going to split the other half, right? If you have kids and no spouse, the kids are going to split it. If you've got no kids and no spouse, then the parents are going to split that, and if the parents aren't there, then it's going to be the cousins. All right. So now, if you don't want your things to be distributed the way the laws of New York say, that's when you want a will. But otherwise, it's going to go just the way I said. Okay, and you may or may not want that. Okay. Now, there's another thing that happens if you die by the rules of intestacy, and that means is that you will not be able to choose who is in charge of your estate, right? It's going to be, there's a list of priority of who gets to become what's called an administrator, right? And the priority list is your spouse, then your kids, then your grandkids, then the parents, your aunts, uncles, things like that. But let's just say you have no spouse, but they're kids. Those kids might fight, who wants to control the estate. That's very common. Or if you do have a spouse, maybe that spouse is not the right person to control your estate, right? Maybe that spouse, maybe when you die, your spouse is 85 years old, and your spouse might not really be capable of dealing with your estate. Or maybe your spouse just has a lot of other things to do. Now, if nobody picks up your estate, then they got this office in 360 Adams Street, which is where the big court is, and it's called the public administrator, and they are going to be your administrator of your estate. But in any case, the administrator is going to have to file a petition with the court. Depending upon how much you have, the petition could be the filing fee for the petition could be as much as $1,250, right? And then they're going to have to serve everybody who has an interest in the estate, all the heirs. They're going to have to serve on those people, and that's going to take a little money, right? So that's what happens if there is no will, right? The other thing I want you to know is that there's some property that is not going to be. There are two different kinds of property. There's property that's called testamentary property, and there's property that's called non-testamentary property. Testamentary assets and non-testamentary assets. The testamentary assets are going to be the assets that are divided in the way I just said, right? The non-testamentary assets are assets. Let's just say, okay, so the first day you go to work, right? If you're like most of us, somebody HR comes in, they're like, sign all this paperwork, right? You're like, I really don't want to do this, right? It's like a lot of paperwork. You're there half a day signing paperwork. We all know that feeling, right? So one of the things that they might have you sign is your 401k. And when you sign your 401k, you're saying, you're probably going to say, if I die, who does that go to, right? And when you do that, that asset is not a testamentary asset, because when you die, that asset's going to be payable upon your death to somebody else. So let's just say I go to work. I go to work, Board of Education. I used to work for Board of Education. So I work for Board of Education. I signed something. It's called a 403B. It's not a 401k, right? And you sign the paperwork and you say it's going to go to my wife when I die. Okay. So when you die, she doesn't have to do anything. That asset's just going to go to her. Same with your life insurance. If you say on your life insurance, I want my wife or I want my nephew to have my life insurance, it's going to go to those people. That's called a non-testamentary asset, and specifically it's called a payable upon death, right? You might have done that even with your bank accounts, all right? So those won't fall under the rules of intestacy, or they're not a testamentary asset. Or if you have a will, they're not going to fall under your will. They're not going to be assets that are subject to your will. Another asset, okay? So let's just say there's another group of assets. They're called jointly owned assets, joint property, right? And specifically, they're called joint tenants with rights of survivorship. So a lot of us, let's just say we bought a house with our spouse. We bought a house with our spouse. Okay, so it's husband and wife owns his house. And it says that on the deed. And it usually says as tenants by the entirety. Or it might say John Doe and Jane Doe own this house as husband and wife. It might say that. Those assets, when you die, they'll go right to your spouse, right? And they're not covered by the will either, right? That's good because, well, it might be good if that's the way you planned it, because it's just going to go right to your spouse. No paperwork needs to get done. The minute you die, it goes to your spouse, and vice versa. The minute he or she dies, it goes right to you. Okay, so those are called jointly owned assets. Some people own bank accounts, and they're jointly owned as well. All right, those get a little bit more complicated as to whose money is whose in that situation, but jointly owned bank accounts. So, yeah, a tenant in common, that means you own the property with somebody else. Okay, so you own the property, but they own a share of the property too. All right. So if you own the property as tenants in common, let's just say you have a boyfriend. You're not married. You have a boyfriend, and you bought the house, and you own it tenants in common with your boyfriend. Okay. When you die, the property is going to go to your heirs. Right. It's not going to go to your boyfriend because you're not married. Right. It's going to go to your heirs if you didn't have a will. Right. It's going to go to your heirs. Right. Your heirs can come and foreclose on the property or partition that property and make him sell it so they can get their money. Similarly, they can sell it to a developer, and the developer can do that, right? Or they can sit on the property and say to your boyfriend, "You're going to pay me rent for the half that I have." All right, they could do anything like that. So I mean, I'm not saying it's good or bad to have property owned that way. It's just what it is. That's the rule.
And it doesn't have to be half and half. When you buy the property,
Right.
Property tenants in common,
Right.
you could say, I have 2/3
Yes.
ownership
Yes.
and you have 1/3.
Yes. Right. So, and that rarely happens, but of course that can happen.
Yeah.
No problem. Okay, so we're cool so far?
Yeah.
So that's if you don't have a will, all right? And that's the property that goes outside of state. So we explained all that. So let's talk about what happens if you got a will, all right? Or what is a will, and why do you want a will? Because if you got a will, you can say, I want my property to go this way. I want my house to go to my nephew. I want my, this property to go to that person, especially if you're, a very simple will is I want all my property to go to my spouse. And you can say that in a will, and that's a good thing a lot of times, especially if you have kids that are young, because what that's going to do is that cuts the kids out. And you might say that's bad. It might be good because if they're under 18, once again, they can't really own property. So you have to get a guardian to take care of it. And once again, it's a mess, right? So you can say in your will, for example, okay, I want my kids to have a certain amount of property, but it's going to be held in trust until they are 18 or 35 or something like that, right? And that's called a testamentary trust, by the way. It's called testamentary. Testamentary means that it's by the will, right? Testamentary really means kind of by the will, right? In this case, so that's a will. That's a trust that was made in the will, right? So you can say in your will, okay, when I die, I want my husband to have half, and I want my kids to have the other half, but it's going to be held in trust until they are of an age that they can be responsible. That's usually what people do. And a lot of people will say something like, I want the kids to have half when they come 25 and the rest when they come 35. Well, the other thing you can do in a will, which is good, is that you can provide for people however you want. Let's just say somebody needs something, that they're going to need something specific. You say, I want them to have $10,000 when I die, because that's going to be an issue. Or somebody who is going to be responsible. Hopefully you're going to pick somebody. Let's just say, I'm 56 now. Let's just say, you pick somebody a little younger than you because you don't want them to be older than you when they're the executive of your estate. Because hopefully you're going to live a long time. If you're 75 and the person's 85 years old, they're not going to want to be the executive, right? So you might want to pick somebody who's your age. If you're, let's just say you're 40, and you can pick somebody your age. If you're 50, you might want to pick somebody who's 40, and you want to pick somebody who didn't go bankrupt 3 times. You want to pick somebody who, seriously, you want to pick somebody who knows how to deal with money, is responsible, and they know they have the same values as you, very important, right? And that they're going to take care of business, right? And that they're not going to steal anything. Because, unfortunately, that can happen. People get funny with money. Now, wills have to be signed in a very particular manner. And when they're signed, they're called being executed, right? To execute the will, all right? And you have to have 2 witnesses. You have to be competent upstairs. You got to know who your family is, who your kids are, and who is entitled, who could get something from you if you died, and you got to know you have to have what's called testamentary capacity, and you got to know what you have, basically, right? You got to know what you have, and then you can't be forced to sign a will unduly. So let's just say you got, let's say you got old, you wanted to do your will, you did your will, and you're 85, you're 90 years old, and you got this homemaid, she's very nice to you, she's cooking for you, she's doing this, she's doing that, and your kids are never coming around, and she says, something, I'm going to stop cooking for you and being nice to you unless you do a new will for me, right? That's called undue influence if you sign that will and you give her everything because she threatened you, right? Unduly. That's called undue influence, right? And I've actually had cases where I've gotten wills thrown out of court for that. I got a will thrown out of court for that. So that's called undue influence. So that can't happen. So when you sign the will, it's got to be two witnesses. You have to ask the witnesses to sign the will. You have to say, this is my will. Here's my signature. I just signed it. That's my signature. Please sign my will. It's called publication. And then they have to sign the will within 30 days.
1 year.
An attorney does not have to be present. But if an attorney is not present, there's something that's called, it's a doctrine, it's called the presumption of regularity, right? And if the attorney's present, the attorney, there's going to be a presumption of regularity, particularly if that attorney's done wills before. You know, if that attorney is a workers' compensation attorney, you know, or is a, whatever kind of attorney, a personal injury attorney, that presumption is not going to be as strong. But if they do this all the time, trust in the states, right, and they're doing wills all the time, and they were present while you did your will, the court is going to presume that the will was executed properly, right? Usually, also at the end of a will, particularly if an attorney does it, there's going to be an affidavit, and the witnesses are going to say, "I was there. The person, Jane Doe, was in her right mind. She could see, she could talk, she could hear, she could speak English, she could write English, and I believe that she was of sound mind when she signed the will, and I believe everything went down okay." That's usually attached to the back of the will, right? So you really want that affidavit at the back. Like in the 90s and before, they didn't use the affidavit so much, but now almost everybody has that affidavit. It's called a self-proving affidavit, right? And it's got to be notarized too. And usually the attorney notarizes it, and at the end of it, it'll say this was supervised by, Antar Jones, an attorney at law, and that means, hopefully that everything was okay. All right. So that's called a self-proving affidavit, right? Okay. If now having said all that, when somebody dies, you have to bring the will to the court. You have to bring a death certificate, of course, and depending upon how much property you have a filing fee. It ranges. Anything over $500,000 is $1,250 filing fee. So if there's a house involved here in Brooklyn, you're probably going to have the $1,250 filing fee. And you come in and you file it, and then you have to. Everybody who is an heir, even if they weren't named in the will, has an opportunity to challenge the will in court. Notwithstanding that clause I just told you, but they do have the opportunity. The court gives them the opportunity to come forward if you want to come forward and challenge, and say that I don't agree with this will. There's that interim clause. They got to live with the consequences of that. If the court finds that interim clause applies. But so you have that. All right. So you go forward now. Since COVID. Okay, so back in the bad old days, I think it was I had a client 2000, I want to say 15 or 16. She was in the hospital. I went to the hospital. She signed the will. She died 3 days later. Lovely lady. Anyway, I went down to court. I got the will through the court in 3 days. This is 2015. Now you'll be lucky if the court will look at the will in 3 or 4 months, right? You're going to be lucky. Right, it's getting better now, but that's what it's been since COVID. Because not as many people are working. They don't have people working. The shifts are different because they don't want people working close to each other in the court, and people are they're operating different. And B, a lot of people died. 4,000 extra people died in Brooklyn in 2020. I think it was 4,000 extra people. So of course there are more deaths. Things are much slower. So in 2 years. Somebody can come forward and say there was no will. I'm going to do an administration proceeding, like as if there was no will. So there are things like that can go down, right? So you want to do that as soon as you can. All right. So
Can I ask a question on that?
yes.
So what rights would they have for them to actually administrate a will after that? Like, what would they have to come forward with?
I mean, after the 2 years or something?
Correct.
Well, you can file the will in 2 years, but if somebody came forward and did an administration proceeding, and they got what are called letters of administration, and the court said that you're the administrator of the estate, and somebody comes forward with the will, there's going to be a problem. The court might say you're out of luck, or if the will wasn't discovered until 2 years later for some reason, you might be able to fight that. Right? I got a case right now that's going on those facts. The will was discovered later, right? But after the administration proceeding, it already happened. A copy of a will is no good. We should talk about that. A copy of a will doesn't really work usually, but I was able to convince the court in this case it did. There are certain circumstances in which the copy of the will is okay, right? It's very narrow circumstances, so you don't want to rely on the copy. Okay, the other thing you don't want to do with the will is, let's say you go to your lawyer, the lawyer staples the will. Do not, and I'm saying this in camera, so this is on tape, do not take the staples out, right? Do not take the staples out, all right? Because that is evidence of somebody messing around with the will. Yeah. It doesn't necessarily mean that they mess with the will, but people are going to be suspicious of that. Now, let's just say there was a will. Let's just say a will. Somebody did a will in 2010. Somebody did a will in 2015. And the same person did the will in 2015. And let's just say that will in 2015 vanished somehow. The court's going to say, well, you got a will in 2010, right? Yes. So, you might not want that. So, most people really want one will just out there. Okay, so the question is, for everybody who might not have heard that, is there going to be an electronic copy once there's a filing in the probate proceeding? What's going to happen is that, well, now in Brooklyn you can't see the will if you're just like a normal person. They make that kind of like secret, quite frankly. But there's an electronic system that has all the documents in the probate proceeding that you can see online. Right? It's something called web surrogate. You Google web surrogate, type in the person's name, John Doe. They come up, and you'll see all the list of documents. Going to include the will, the death certificate, and some other documents. Now, okay, about a couple of years ago, they said we don't want you looking at the death certificates because it's got their social on there. And somebody called me up once, this on the side, and she's like, I think somebody sold my daddy's house. I looked at it. This guy died. Like 7 years later, he signed a deed and gave it to somebody. He was dead, right? I swear, I saw it. I saw it with my own eyes. I couldn't believe it. But the homeowners here, you always got to be very careful about that stuff. Okay. What you also can do is that you can have a life estate in the house and give the house to somebody else. So, for example, let's just say you've got. Let's say you have a son, right? And you say, I want to give the house to my son. I want to live in the house, but I want my son to have it after I die. You can say, I'm going to give the house to my son, but I'm going to have a life estate in the house. That means I get to enjoy the house for the rest of my life. I get to do whatever I want. I get to have tenants. I get to kick the tenants out if I want. I get to get the rent from the tenants. My son's getting none of that. But when I die, it goes to him. Boom. Easy. All right? That's a life estate. Now, technically speaking, with the life estate, though, he owns the house. And you're just, it's called a life tenant. You can also put in the will. When I die, my house goes to my son. Right? The good thing about that is that when you die, you're going to get something that's called a step up in basis. So let's just say you bought, let's just say, there are a whole bunch of people in Park Slope who've got $4 million houses now. They bought the house for $30,000, and they're in their 80s now, right? Literally, $30,000. But when they die, they're going to have to pay the person who gets that house. Let's say you sell the house, they're going to have to pay gain on $3,700,000, right? And so there's going to be a huge tax. But if you die and you give the house in your will, you're going to get a step up in basis, right? That means that on your date of death, there's going to be zero gain. The basis of the house is going to be the value of the house at the date of death. So let's just say you died, that house was worth $4 million. Instead of paying on that $3 million and change tax, you're going to pay zero, right? So that's the advantage of putting it in a will, all right? If you put it in a living trust, the same thing is going to happen. A revocable trust, the same thing is going to happen. you're still going to get that step up in basis, right? And the advantage of putting in the trust is that you don't have to go to probate, right? Because it's in the trust already. And you can set the terms of what's going to happen to the house, who takes care of everything in the trust. You know, my son's going to take care of the house, you know, when I'm incompetent. You define what incompetent means, you know, my son, or maybe upon my death, my son will take care of the house. But whatever, you're still going to get that step up in basis. So that's a revocable living trust, all right? Right? If you put it into an irrevocable trust, it's like giving it to somebody else. And the basis is going to be the basis of when you bought it. It's just going to be, you're just going to transfer the basis over. So you're still going to have that huge, you're going to have that
Capital gain.
that gain. You have that gain,
You have to
right?
pay taxes on that gain.
Yeah, you have to pay taxes on the gain, right? But you're not going to get that big step up in basis, for sure, all right? So, so that's that. So, but the advantage of putting into an irrevocable trust is that if you got creditors, they can't get to it, right? If you're worth a lot of money, it's going to make your estate look smaller. If you put it in a revocable trust, the property is not going to be yours anymore. It's going to be the trustees. And you know, some people, they want to impoverish themselves for Medicaid purposes. If you give the property away, you know, there's a 5-year look back period, but you know, you'll be eligible for Medicaid. Okay, so the difference between a revocable trust is just the way it sounds. You can revoke it. You can also change it. You can take property in and out of it. You don't have to worry about, you know, especially if you were the only person putting property in it and you're the only trustee, you don't have to work. You can amend it. You know, you have to do the paperwork the right way, but you can amend it. You can change it very easily, right? It's also the property that you put into a revocable trust is part of your taxable estate for tax purposes, for Medicaid purposes as well, right? It's part of your estate. But on the other hand, an irrevocable trust is irrevocable, meaning that you can't change it, right? Unless you talk to all the beneficiaries and they all agree that you can change it. You know, a lot of times, though, a lot of the beneficiaries are kids. And they can't sign anything saying that they're changing it, so you're kind of stuck, right? And that property is not yours, right? So we learned when we took the bar, I remember this. Nobody else remembers this, but I remember it. Okay, so when you give your property to a trust, the trustee is the legal owner of the property, and the beneficiaries are the beneficial owners of the property, right? They benefit from the property, but the trustee is the person who's taking care of the property, right? So with an irrevocable trust, the trustee owns that property, right? And they can come in, they can fix the property, you know, they're going to collect the rents from the property, that kind of thing, right? They're the owners of the property.
So,
Oh, go ahead.
so for the revocable trust, creditors can get into come for the
Absolutely.
revocable trust.
Absolutely.
Right. Okay.
Right? Everybody tries to get around that, and the creditors can get it at the end of the day.
And with the revocable trust, there is no probate.
With either of the trusts, there's no probate.
Oh, so either trust. Okay.
There's no probate. But if it's a testamentary trust, because it's in the will, of course there's going to be probate because you have to probate the will. Because the testamentary trust, the terms of the trust are literally written in the will, right?
Okay.
So it says, when I die, I give my house to my daughter, but if she is under the age of 18, it's going to go into trust. That's what the will says, right? So that means the terms of the trust are written in the will. That's a testamentary trust, right?
Okay.
So you got to go to get the will probated, right? And at the end of the day, the judge is going to be the only person who says that will is good or not, all right? So, but with these trusts, the great thing about the trust is that you don't need to go to probate and spend the $1,250, you know, pay a lawyer, you know, usually now it's going to be no less than $5,000, you know, $7,500, maybe more if you got a big family. Well, when you have a will, all the distributees, they're called, the people who are entitled to the estate if there was no will, have to be served. And all the people who are entitled to the will it's just something under the will, at least have to be noticed. The notice might be publishing an article in the paper. If they can't get a hold of you, they're just going to publish an article in the paper. That's how a lot of papers make their money these days.
Yeah.
So you look in the back of the paper and you see all these, like, they look like,
Yes.
who knows what they look like?
Yeah.
They're all advertisements.
Yeah.
That's what a lot of them are. They're published. They're saying there's a will out here. You know, somebody in Clarendon Road died, and here's the will, and here's your notice. You're never going to read it, but
It was sent you.
But it was sent out.
Yes.
yeah. So that's how. Well, the witnesses should not be beneficiaries in the will. By the way.
No.
Right. So
how was that? That sounds like it's.
Well, it happens all the time.
It sounds like a counter reaction. Like, how are we doing that? Two people, the witnesses are not the people that are actually people that are on the boat.
Okay, so let's let's just say Angie wants to do a will. Two of her neighbors. She gives all. I'm just making an example. She gives her will to her. She gives stuff to her family. She invites two of her neighbors to have some wine and cheese while they're witnesses to the will. That's how it's done. I forgot to tell you. Let me change the subject for a
That's why it
second.
makes sense
Hold on
now.
one minute, guys. Hold on. Go ahead.
Okay, so let's just say you have if you have a will, you've got to give in New York. You got to give your spouse a third. That's the law. All right. So I didn't tell you that, but they're entitled. They're entitled to a third. Right. It's called
Automatic.
the third of the estate.
Yeah.
Yeah. In a will, they're entitled to a third. You know. So in a will, right?
Even if they're not in the will, they're entitled to a third of the estate. and the
Yes.
rest of-
So let's just say you didn't put them. You went out of your way to not put your spouse in your will.
Right.
Your spouse could come back later and say, I'm exercising what's called my right of election,
Okay.
and I want my third. So listen, we're going to wrap up. I just wanted to say two quick things. You got healthcare proxies, and those are documents where you can give somebody the right to take care of your health decisions when you die, right? And then you got a power of attorney, and that will give somebody the power to deal with your business affairs now or either when you become incompetent. If you know, but you got to do it the way you want to do that, right? And that can get a little complicated. We're done.
All right. Thank you so much.
Thank you.
Thank
Thank
you.
Thank you.
Back next Tuesday, same time, same place.
Thank you so much. Thank you for all your great questions. I hope that this was
Okay.
informational
Okay.
for you guys and beneficial. As I said, this is the first of our Khawly Knowledge Bar series where I hope to collaborate with other attorneys in other areas of specialty that I think are relevant to our community, that are relevant to your everyday life. If there is a topic that you'd like me to cover, that that you want to learn more about, please tell me, please reach out. I want to be able to educate because I truly believe that knowledge is power.